I'm very grateful to be here. I'm very excited to see so many people interested. I know you're here for Jeff, and you just got stuck with me for the next hour. So, what we're going to talk about tonight is a subject that I've been teaching on for 5 or 6 years. I was actually part of a board effort to try and form the state of Columbia in the 1970s, which would have been eastern Washington, northern Idaho, and western Montana. That was back when everybody who did that had tinfoil hats on. So it was a first volley, if you will, in that salvo of trying to make people understand what a state is. And the founders understood what a state was. They understood very carefully what it was. And when you see in the Declaration of Independence that they said, they called the colonies, they said these colonies are of right and ought to be independent states. And when they said independent states, they were using a term that was understood at the time and still should be understood. If I say the Nazi state, what would you think I was talking about in World War II?
Nazi government.
Germany, the country of Germany was a Nazi state. When the 13 colonies, by the resolution of 1775 and later on the Declaration of Independence, removed themselves from the control of Great Britain, they declared themselves independent states. And what they meant by that was tracts of land with the same equality as Spain, Germany, Portugal. And they said it was appropriate, it was decent of them to give the world their opinion as to why they were doing that, if you read that in the Declaration. So, when we're talking about the state of Idaho, the original intent of the founders was that back then the 13 states, they were independent nations who by their own choice unified to fight a war against Great Britain. And afterwards they formed a constitution, which I know most of you, if not all of you, have studied. They formed that constitution to govern them, and to govern them in the minimalist way that the founders intended. Never let it be said that they separated from Great Britain, a controlling country, so that they could submit themselves to another superimposed control. The idea was to be gaining freedom. And so what they did was they created the United States, small u, and what those United States were the people who had gathered, they were the people who were sovereign over those states, who had gathered together to form a new nation. So they were as much a nation as each state was as much a nation as Great Britain or Germany. And they voluntarily ceded some of their power, now cede is the wrong word, delegated some of their powers to a new fledgling federal government, and they adopted that constitution in 1787, and later on the Bill of Rights in 1791. But what I'm trying to give you this basis for, many of you probably already know it, but when we talk about state lands, what we're talking about is a country who ought to have control over its territory. A country, like if we went to Spain and tried to take some of Spain's land and make it into a national park, the country of Spain would have something to say about that, would they not? Idaho does not have much to say about what is made into a national park, and that is an egregious violation of the United States Constitution, the Equal Footing Doctrine, and subsequent legislation. So, starting out on this now with that as a basis, understanding that each state is in a sense, a sovereign nation. We're looking at, if you look at this representation, can everybody see it with that light? Okay. Texas is 2.7% federal. What that means is the forts, the federal ports around the borderline of Texas, when you add up all of their properties, and the reason I'm talking loud is so that the camera will pick it up, and because I talk loud all the time. When you add all that land space up, it equals approximately, I think it's 2,700 square miles total, which is smaller than Boundary County. Or I guess a little bigger than Boundary County, but not much. But that's all Texas has ceded to the United States government to have responsibility or jurisdiction over. So Idaho is 63%. And that is approximately a piece of land about the size of the state of Arkansas, about 51,000 square miles, that is controlled by the federal government. It is not federal land. It is Idaho land that has not had title extinguished properly. In 1777, the colonies were those new nations were coming up with their first constitution, the Articles of Confederation. And late in the debates in the late 1779, 1780, one of the things that was stopping them from forming the Articles of Confederation and finishing the job was, what do we do with anybody who comes into this new nation and becomes a state? What happens when the territories to the west of the 13 colonies, if they so choose, become a state? How do we deal with that? So the resolution of 1780 was written and passed, and that resolution was a federal trust obligating the United States to extinguish their governmental jurisdiction and title to lands that achieve statehood. That's part of the doctrine of the resolution of 1780. When you talk to a realtor about extinguishing title, Dawn is a realtor, so she can correct me if I need it. But basically what that means is someone owns title to something, and they've decided to cede that title, or they're responsible to give that title over to someone else, whether it's a quitclaim or some other variation of a removal of their control of land to someone else. What the federal government was supposed to do is look at its lands. Okay, these are treaty lands that we have with the indigenous nations of Indians. These are lands that we have forts on. These are lands that so we're not going to extinguish those titles, but the rest of this we're going to extinguish title to and cede it back to the states where it properly belongs. That was part of the resolution of 1780. It was also the equal footing doctrine, which we'll talk about in a little bit. Now, there's an awful lot of talk about Article 6 today, the Supremacy Clause, and an awful lot of misunderstanding of the Supremacy Clause as well. And I want to say something here. I'm not arrogant. I'm not smarter than anybody else. But the Constitution was written so that the average 8th grader at the time could understand it. That would be about 17th grader nowadays. But anyway, the average American citizen of the day understood the Constitution very well. And the Federalist Papers, all 85 of them, were written by 3 people who were trying to convince the United States, the citizens, to encourage their state legislatures to ratify the Constitution. So I'm not smarter than anybody else, but I believe I understand what the Constitution says. It's actually pretty clear what it says. You actually need to have a law degree to screw it up. And that's done very well nowadays by many of our barristers. That's like coffee maker, but that's a barista. Okay. Anyway, Article 6, Clause 1. All debts contracted and all engagements entered into. An engagement would be a contract or any kind of a legal document that the United States was obligated to keep before we passed the actual Constitution. All debts contracted and engagement entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation, the Articles of Confederation. So the resolution of 1780 was valid under the Articles of Confederation. It was never revoked, it was never subsumed, it was never removed. Therefore, it's valid under the Constitution. And the resolution of 1780 obligated the states, the United States government, federal government, to extinguish title to unclaimed lands in the territories to the west whenever those territories formed states. That was the resolution of 1780. Article 6, Clause 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, or in accordance with, or under the jurisdiction of, or that work not against this Constitution. I'm making things up now, but it's true. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made. Oh, by the way, that's why TPP is a violation of the Constitution. It's a treaty with 12 sovereign nations. You can't make a treaty with 12 sovereign nations. And when 2/3 of the Senate concurs, then maybe I'll concede that it's an actual treaty. But 2/3 of the Senate's not being asked. Back to Clause 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and things in the Constitution or law of any state to the contrary notwithstanding. Remember, in pursuance thereof. That is so significant, and it was clearly understood in those days. They understood that if a law was made that violated the Constitution, it was not a law. It was a usurpation, and Alexander Hamilton, big government Hamilton, he was the big government guy at the time, wanted the big central government. He said it was a usurpation and deserved to be treated as such and ignored. He said that. Article 6, Clause 3, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states shall be bound by oath or affirmation to support this Constitution. Note this engagement, Article 6, has been amended and continues to be put in as note this engagement. I'm sorry, I'm getting ahead of myself. I do that all the time. I always say, don't get ahead of yourself tonight. Get your hamburger after you're done. This engagement, the resolution of 1780, and Article 6, neither one of those have been amended, and they continue to be part of the supreme law of the land. Federal lands policy. The federal government stopped ceding the lands to the western states in the late 1800s, 1880. Now, a lot of you may or may not have known this, and I'm going to try and answer some of the objections that are raised as I go along. People will say that state wrote in their constitutions that they disclaimed all control and jurisdiction over the federal lands in the country, in the state. They disclaimed it. Many states did that. North Dakota said that. Washington said that. Idaho said that. South Dakota said that. In 1890, within a 6-month period, Idaho and North Dakota became states. The federal government ceded back to North Dakota all but 3.5% of their land, and they ceded back to Idaho 0. And the reason was because they could. There's no constitutional reason. Both states have the same language. We'll see that in a little bit here. In 1976, the federal government kind of did something like this. You know, we've been doing this for almost 100 years. We're not supposed to be doing this. We better say something about it. So in FLPMA, the federal, and I put RLPMA because I wasn't paying attention, and R, is R anywhere near F on the keyboard? Because if that's what, yeah, okay, that's my excuse. I'll correct that. I'm actually going to circle it. It should say FLPMA, Federal Land Policy Management Act. The Federal Lands Policy Management Act of 1976, which, by the way, contains all the procedures and provisions for coordination. Maybe some of you know what that is. It contains some really good stuff. But it simply declared this, that it is the policy of the United States that the public lands be retained in federal ownership. Take that, states, and shove it, is basically what the federal government said at that point. So, we have the resolution of 1780. We have, I'll get to it, the doctrine of the equal footing doctrine, and we have the fact that it was known at the time that any lands that were not state forts, magazines, docks, etc., or Washington D.C., would be given back to the states. It's already been done before in the period 1810 to 1830. The western states, which at the time would have been Louisiana, Missouri, Illinois, Indiana, etc., they had the same problem. Missouri was 90% federal in 1810. And they couldn't fund their county road crews. They couldn't fund their schools. They had the very same problems. If you read their petitions to the federal government in the in the legislation and the resolutions they wrote to the federal government, you'll see some of the same language that we have today, where county commissioners, like in Custer County, which is 97% federal, they have to use 3% of their land base to derive their property taxes to take care of their whatever county departments they have, 3% of their land. Missouri was complaining for the same reason. Indiana was complaining for the same reason. They petitioned the states, they persisted, and they got their land back. As much as 90% of those lands were federally controlled for decades. With so much land under federal control, these states persistently argued that they could not adequately fund education, grow their economies, responsibly manage their abundant resources. They couldn't stop a wildfire. Has that ever happened?
No.
Oh, okay. It hasn't. Okay. They banded together, they refused to be silent or take no for an answer, and they compelled Congress to transfer title to their lands. In 1959, Congress granted directly to the state of Hawaii, the last and westernmost state, the United States title to all the public lands within the boundaries of the state of Hawaii. This is a quote. Title to which is held by the United States immediately prior to its admission in the Union.
So Hawaii did this.
This is in the state of Idaho's Constitution. It is ordained by the state of Idaho, and the people of the state of Idaho decree and declare that we forever disclaim all right and title to the unappropriated public lands lying within the boundaries thereof, and to all lands lying within the said limits, owned or held by Indians or Indian tribes, and until the title thereto shall have been extinguished by the United States. That's pretty clear. Go ahead and keep the land, United States. Take whatever time is necessary. They're thinking 5, 10 years. Figure out what lands you need to keep for forts, magazines, docks, dockyards, and needful buildings, and what lands are under the jurisdiction of the Indian tribes, and then give the rest back to us. We'll be patient until you extinguish title. It's never happened.
Wow.
That's in our state constitution. The Washington State Enabling Act, they said the same thing, until the title thereto shall have been extinguished. These enabling acts are very instructive, and something that they're a little bit more fun to do than watching milk sour, but they really are interesting when you read through them, and they don't have pictures. Article 1, Section 7, Clause 17. Congress was given authority to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. Where's that? Washington diseased. And by session, they had to even give that. By session, particular states in the acceptance of Congress become the seat of the government of the United States. As may, not as shall. Do you note that? That's significant language in the Constitution. The federal government acknowledged that they were asking the states to give this land over, this 10 square miles. They weren't directing it, because they couldn't. The federal government was created by the sovereign state governments. Okay. Those are significant points. They really are. And shall become the seat of government of the United States and the most destructive piece of land to ever exist on the planet. Oh, it doesn't say that. Well, anyway. And to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other buildings. Do we have 51,000 square miles of dockyards in Idaho?
No.
We got room for a lot of tanks and ships, if they ever want to bring them here. Now this makes sense. On California's admission to the Union, she became the owner of all the public land not disposed of by law of Congress. Friedman versus Goodwin, 1856. Flipma. It is the, I got it right there. My fat fingers weren't doing it there. It is the policy of the United States that the public land shall be retained in ownership. Violated the resolution of 1780, which was to be followed per Article 6 of the Constitution, and was followed for 38 states, all the way to Colorado. It was followed. It was obeyed. After a territory becomes a state, upon return of the lands to the state, if the federal government needs land for an Article 1, Section 8, Clause 17 item, it must purchase the land back. Do you think the federal government can afford 51,000 square miles of Idaho?
Sure. Print money.
Yeah, that's true.
They'll just borrow it.
Sure, we can just print it up. I've got some at home. It's called Monopoly. And they purchase the land back if the state legislature consents to the purchase. Not only do they have to purchase it, but it's a may in the Constitution. It's a may, not a shall. And the reason I'm emphasizing this is because the emphasis the federal government or the states put in the Constitution was that they were delegating the power to the Fed. They were ceding some responsibilities, and they enumerated them carefully. That's why this book that's why it's not very big. It doesn't have that much. Thus, only a state, you talked about this, John, only a state can create parks. Only a state can create forest reserves. Only a state can create wildlife refuges and monuments. The federal government may hold no land in a state for non-constitutional purposes. And if you have any questions, yes.
Maybe you're going to get to this, but was the Homestead Act a federal act, and how does that play into?
The Homestead Act is a federal act.
And how does it play into the releasing of federal land?
It was an improper way to do it, but it got done, and I don't like it. But I'm Baptist, and I don't like anything. The equal footing doctrine. The admission of new states, legally, these are legal terms, shall be on equal footing with all states in all respects whatever. Financial, property owning, governmentally, Article 4 of the Constitution says that the federal government guarantees every state a democracy.
No.
Thank you. What does it guarantee them? What kind of government does it guarantee them? A Republican form of government. Significant.
Rule of law. Not a
Rule of law. Article 4, Section 4, the United States shall guarantee to every state of this union a Republican